Okay, well, thanks. I'm just going to hit 2 points that I thought were interesting from our table discussion. The main one was that if the parties had had a well-drafted contract between themselves, they might have been able to avoid all of this. Perhaps their contract should have said that you have a continuing obligation to disclose any information that you get, any kind of surveys, tests, appraisals, anything like that. Or perhaps they should have gone ahead up front and agreed to have 2 appraisals and a review appraisal if they needed one, and that might have resolved all this. We also thought that at the point that Alice's attorney, Alice, at the point that Alice learned that her client had gotten the appraisal from the BlackBerry, that she probably was bound to try to terminate that relationship at that point, because then if she did not, she might be perpetuating an illegal activity. And let's see, we had some concerns or some questions about whether there was fraud involved, and we decided that probably the best thing to do is to always pick up the phone and call the bar. Don't try to interpret this stuff for yourself. Thanks.
Works for me. Carlyn, while she's coming up, I want to be sure to give a little credit where credit's due, because I know once this is over, you're going to be racing for the exits. Carlyn and Robin and Doug Brocker, Shannon Joseph, chairman of the committee, Lori Vitale, was very active with Doug in developing the problem, so you can blame it all on them. But thanks to these people. I think it's okay to give them a little applause.
And I can't take credit for the problem. All I said was, good job. Interesting problem. The group at my table, I thought it might be interesting for everybody to know sort of the cross-section of people there. So our group ranged from a third-year law student to a person who has been practicing law here in Wake County for 30 years. Most of the people at our table had been in practice for 7 or 8 years, and practice experience ranged from working in the city attorney's office to working in large law firms to medium-sized law firms. And now, at this point, several people at our table are in solo practice. And Tom Dimmock, a person at our table, is sort of back to where he started, doing his own typing and taking care of his own bookkeeping and taking care of his law practice. So a wide range of experience and points of view at our table. And we focused most of our discussion on the first situation, and we spent a lot of time talking about the particular problems of email, and how if this information had come buried in the body of a letter, there would have been ample warning for the attorney who had inadvertently received it to say, oh, here is something that says Dear Larry, or here is something that's addressed to someone else, before getting down to the meat of the problem of, oh, here's this number that says $5 million instead of $12 million. We talked a little bit about how the email might have been addressed, so that, you know, if it needed to be opened, it still could have been opened inadvertently. And then again, this very short message, so that it would have been very difficult for the attorney not to know what was in the email, because it was there in just a couple of sentences. And in an older form of communication by mail, this problem would have been, there might have been an easier answer, because the attorney could simply have stopped reading. In this particular case, we thought, is it really practical to think that somebody's going to stop reading a 2-sentence item with numbers jump out at you? So we spent a long time just talking about sort of the practicalities and the technicalities of that, of how do you stop reading if there's a really short message like this, and what obligation do we have to be, you know, paying really particular attention to how emails are addressed. And then we talked about some technology that sometimes the message comes up without even opening it. So we talked a lot about the nature of the beast and how that presents a particular problem. And then we had much of the same discussion as the other table about what did the contract actually say. If there was a particular contract that said we are going to set the price of this business in this way with a joint appraisal, and if both parties were bound by that contract, or was there fraud, or had something happened within a 6-month period, and what the timing of these appraisals, what difference did that make? And in complete agreement about the BlackBerry, that that this is illegally obtained information, and so there would be some obligation to withdraw. And Doug is going to tell us now, here's the word on that.
Thank you, Carl. Doug Brocker practices in this area, and Doug does a microphone down there if you want to use it. You can come up and use this one, whichever. Come right here.
Thank you, Judge. I'm just going to highlight some of the rules. I'll say that for some of these issues, particularly the professionalism, there is no right answer. I can't necessarily give one. This is kind of the consensus of the folks who put it together. But one of the reasons that we thought this would be helpful was that this is an area where the state bar rules really have changed significantly over the last couple of years. The first set of questions are about whether there was any ethics or professionalism violation in the first scenario with Alice actually reading the email. And I think the clear answer, one of the few clear answers there, is there's not any, certainly not any ethics violations for her reading the email. Professionalism question may depend on how much information was there that should have given her a clue that it was something amiss, but it sort of presupposes that she didn't know until after she had read it. That's fairly clear. The other fairly clear principle from the rules, which is 4.4, it's in the materials, the supplemental materials, the rule package, is that the one obligation that she really does have in that scenario, or in both of the scenarios, is to call the other lawyer and let them know that she has received it. That is the one thing the ethics rules say you must do. The idea behind that is that you, the other lawyer should have an opportunity to try to take some steps to keep that information from going any further. Beyond that, the ethics rules really leave it to a matter of professional discretion. And there's a specific comment in there about that it is in the discretion of the lawyer, professional discretion, about whether or not to disclose it to the client. And I read that certainly to say that means you will not be cited for not zealously representing your client if that's what you choose to do in that scenario. The other probably significant point with respect to that rule is that there was a prior opinion, which is in the material, RPC 252, and I think a lot of people have read that opinion, at least from the people I've talked to, which imposed more requirements than you now have, which essentially said if you get it and you know what it is, you not only have to tell them, but you have to not read it, and you have to return it as directed by the lawyer. You can still choose to do that as a matter of professionalism, but you're not required to do so as a matter of the ethics rules. And that opinion essentially has been overruled by the new 4.4. And I think a lot of people are aware of that and maybe not aware that the rule has actually changed. The other questions, the other thing that's not raised, I guess, or it's in the rule package that's not specifically raised in the question is, has Larry violated any ethics rules? And I think, in my mind, probably he has with respect to Rule 1.6 and confidentiality. Frankly, he's probably got more problem with the liability carrier than he does with the state bar for a $7 million transaction. But there's no intentional requirement in the disclosure of confidential information. And what that really highlights is you've got to be, it's essentially a strict liability kind of standard. You've got to make sure that information does not get out. And I won't repeat the comments that Carlyn made, but I think email is particularly difficult and problematic with that kind of sensitive information. So the final point I'll make with respect to the rules and the question is, it doesn't really, there's no real clear answer, at least not in my mind, about what happens when the client gets the information from the BlackBerry. But what that really is intended to highlight is the rules also say you don't have any obligation about returning the information or not reading it under the ethics rules, but there may be other laws out there which would prohibit you using that information. A clear example in my mind is if you know somebody got information by illegally wiretapping, the ethics rules wouldn't say you need it, but the criminal law probably says you can't. So you need to consider those as well. Thank you all, and appreciate your participation.
Thank you guys for being here. Our next speaker is a continuation of the preview you saw before. This is Doug Brocker, and he will be talking on establishing, maintaining, and using an ethical website.
Thank you. I'm sorry we're getting started a little bit later. Can you hear me in the back? Okay. Everything's set up, of course, and then my computer freezes right before we're starting to go on. So hopefully we won't run into that problem. I did this program a couple of weeks ago for the Bar Association as part of the Law Technology Expo. And when they asked me to do it, I thought it would be a good topic because not only are the technological advances moving so quickly, but the State Bar has tried to keep up in a good number of ethics opinions, and those have changed fairly frequently. So, you know, when I was reviewing this, I sort of reconfirmed that idea about how quickly things are moving. There's a manuscript in the materials, and behind that, there's essentially all of the rules and opinions that I'm going to talk about, or at least reference the substantive rules from. And as I was going back through and reading the opinions, I was just struck at that the change in things. I was reading through an opinion that's 2000 Formal Ethics 1, which was in April of 2000, which is just a little over 6 years ago. And the opinion starts out, this is a formal published opinion from the State Bar about using websites and certain information. And the opinion starts out, law firm is setting up a site or web page on the World Wide Web. And then it goes on and talks about, you know, that it's going to be displayed on the internet, a network of interconnected computers. Like, this is some foreign concept 6 years ago that nobody has any idea what we're talking about. And then just last year, less than 6 years later, they issued an opinion, which I'm going to talk about a little bit more at the end, which is 2005 Formal Ethics Opinion 10. And that opinion is on what they call the virtual law practice. And essentially, in less than 6 years, we've gone from the State Bar saying they have to explain what the internet is to a lawyer who is proposing to do everything over the website and over the internet. They are soliciting clients and providing all legal services through the internet. So it really has moved quite quickly, and there are a number of topics that I want to cover in about 45 minutes time. And essentially, the first one is establishing a website. What are the issues involved with establishing a website, and then maintaining a site, and specifically the content of it. Using a website to attract potential clients. Disclaimers is another issue. If you have email links on your website, terms of use or disclaimer are important. Then I'm going to segue into using a website to actually deliver legal services. How is that being done, or can it be done? And then sort of what I call the wave of the future, which is a reference to that virtual law practice opinion, unbundled legal services, either through the website or somewhere else, and then application service providers. The first step, and I'm going to go through this fairly quickly, the first step if you're either setting up your website or you're thinking about redesigning it is to decide what the purpose of the website is going to be. Initially, when people set them up, they would what I called really passive marketing. Essentially, they put information out on the web, such as firm practice areas, clients, attorney bios, that type of information that people could go and they could find the firm. They could look for the name of the firm. They could look at it. I think increasingly people are using websites to what I call actively market. That includes lots of different concepts, including everything from using meta tags to manipulate search engines, including links from other legal referral or legal websites. That also increases the optimization, which essentially means the chances that you're going to come up higher than anybody else when they're looking for legal services. A lot of folks actually solicit legal questions on their websites, ask people to send them in, and also targeting a specific legal market. And that's, I want to, throughout this, I'm going to try, if my computer doesn't freeze up on me again, to give you some illustrations of things that I've found. One of those, let's see, talking about targeted sites and how people have gone about. There were some that I found outside of North Carolina that I thought were particularly interesting ways that were clearly targeted towards a particular market. Let's see. This one is called Hurt 911. Hopefully I can pull it up here. Give me a second. Take me a minute. 1-800-HURT-911. When you're hurt in an accident, call 911, then call 1-800-HURT-911. So he's clearly going after a particular market. Wouldn't necessarily, I'm not necessarily endorsing these websites, but clearly he's got something specific that he's going after. And he's also got a paid 1-800 number, and his domain name, everything ties into that same thing. So let's see, find us another one here. And another one who has a very specific legal market. This is a guy actually out of California. Dog bite law. And if you go through this, you'll see that Mr. Attorney Kenneth Phillips has a unique law practice. He represents only people who have been bitten by a dog. Very selective practice. He doesn't just represent anybody who's been bitten by a dog, only the real serious cases. And if you scroll down through his website, you can see that apparently he's even been on CNN for his expertise in dog bite law. So he's got a fairly clear market. The out-of-state one that I sort of like the best, let's see, was, see if I can get it to come up here. This is another California lawyer. There's a trend developing here. The Mixed Up Adventures of lawgirl.com. I know what you're thinking, you know, all this purple and these, I don't know what in the world these cards are over here, but you can ask Law Girl a question, read about all her interviews. She's apparently an aspiring entertainment lawyer, entertainment law, and but in fact, if you go down to the bottom here, I'm not sure what the purpose of these cards are. This is actually a lawyer's website, Jody Sachs Esquire from Los Angeles, California. So again, has a real idea of what they want to market. I'm not sure how effective it is, but the last one I'm actually going to show you here is from North Carolina, who I think, in my view, has a very specific opinion or market she's targeting. This is, from what I was told, the newest lawyer in Fayetteville, who is got a sort of self-portrait there on the website and appears to be targeting a specific market in the Fayetteville-Fort Bragg area, but I don't know. No word yet on whether or not it's been effective. So those are some of the examples of targeted websites. And you really need, in seriousness, though, you really do need to decide what your purpose is going to be for this site, and that sort of directs everything. Once you get to that point, you need to know what rules apply. The North Carolina Rules of Professional Conduct now explicitly say that they apply, the general advertising rules apply to websites. Also, general advertising rules apply regardless of whether you're just using the website as passive marketing or active marketing. Regardless, they consider that to be advertisement, and all of the same rules apply. And I'm not going to go through the standard advertising rule. They're in the package. You can't have misleading information. You can't create unjustified expectations. You can't compare your services with somebody else unless you can justify it. The next step, which people may not consider to be something that would normally be covered within the ethics rules, is selecting a domain or URL name. And this can be for the initial site, but you also can have multiple URL sites and cross-link them. But the State Bar has said that if your domain name is more than a minor variation of the official name of the firm, it must be a trade name registered with the State Bar. So if you're going to have something, and I'll give you some examples of things that have been cited, that's something other than the name of your firm, you've got to actually register that just like any other trade name. And that's the opinion that said that just within the last year. On the other hand, you can have domain names even when it's not apparent that the law firm it's a law firm website, as long as your homepage identifies the site as a law firm. So the domain name itself can be something that you would have no idea was a law firm name, but as long as when you hit it and you go to the web page, it identifies it as a law firm. That's okay. And people have done that. And there's one lawyer here in North Carolina who has over 20 different domain names for his website, and he cross-links all of them and increases the optimization on searches, presumably. The main thing is it can't be false or misleading. An example of that just pops to mind is you couldn't have a domain name that was North Carolina's best personal injury lawyer, or something that would clearly not be easily substantiated. There are lots of other examples, but that's one that comes to mind. There are a number of these that have been registered. I sort of have put them in categories. There's a whole slew of them for people that do personal injury law. Drug injury, North Carolina Workers Injury, Drug Injury Watch, Carolina. Those are all names that have been registered with the State Bar. Some of them are by the same lawyer or law firm. And that's perfectly acceptable as long as you register it. Lawfortheaged.com, My North Carolina Will. I'm going to come back and look at that in a minute for another point. But those are obviously targeted at people who do elder law. Bankruptcy, some bankruptcy names. I mean, the purpose of this, if you're not aware of it, is it increases the chances that you're going to get ranked higher when people go and do a search if you use the domain name that corresponds. Now, here's just some bizarre ones, and I'm going to take a look at some of these. But these are some of the ones that have been approved: LawyersForChrist.com, AttorneysYouCanCountOn.com, Ask the Law Guy, Dealer Lawyer. I'm not sure. I looked that up. I really couldn't understand the point of that. But let me show you the one that really got my attention was the Lawyers for Christ. So I have to go look at that. Let's see. Give me a second here. Here we go. Trade names. All right. Here it is. Lawyers for Christ. This is actually a firm in North Carolina. Mission statement is to provide professional, courteous, and competent legal services and spiritual counseling to all our clients, recognize that we are ultimately accountable to God for those whom we have entrusted to us. So they apparently think that there is a higher authority than the State Bar that they have to account to. Don't know whether that's an effective way to market or not, but the State Bar has approved it. So if you can come up with it, you can submit it to the bar and see whether or not they'll sign off on it. The last category is sort of cashing in on the electronic cyber law kind of modality. But if you're using a website and it's not the name of the firm, the UAR, the first thing you need to do is to go back and actually register that. And just looking through people that I knew had those out there, I think there's a lot of folks out there that are not aware of that because they're not registered and they're using the names. Probably a competitor is the most likely one to report that. All right, with respect to website content, a couple of things that are actually required. I'm going to flip through these kind of quick. Like any advertisement, a website must affirmatively identify a physical office address rather than a P.O. box. Not a big issue for most people, but it is a big issue in the eastern part of the state where a lot of lawyers who are licensed in other states come in and take clients here in North Carolina, and a lot of people are upset about that. So you want to make sure that's in there. And the other thing that's important about a website is, unlike a Yellow Pages ad, because it is changeable so quickly, you have an obligation to change it and keep it current. That's generally, you're not going to be able to say like you would a Yellow Pages ad, there's a problem, well, there's nothing we can do for a year. You really have got to monitor and keep it current. Another issue unique to websites for advertisement is you really need to identify what jurisdictions you practice the law in. And that's particularly true if you work for a firm that holds itself out as a regional or a national firm, because obviously that information is available to anybody anywhere in the world, and so the State Bar has said that your failure to do so could end up getting you into trouble with other jurisdictions. One of the things that comes up fairly regularly, because it's both controversial and if it can be done, I think pretty effective on websites, is client testimonials and endorsements. There are certain things you can do, and there are certain things you can't do. The The things that are permissible generally are what I would refer to as soft endorsements. People saying, the client saying, oh, he was wonderful, called me back all the time, handled my case quickly and efficiently, things of those nature. As long as it's truthful and it's in that category, it's fine. The things that are prohibited, like any advertisement, you can't use actors to pose as clients. If you're going to actually have a picture of a client on your website next to a testimony, it has to be the client. It's considered misleading to use an actor, just like it would be in a TV. Probably the biggest one is that you cannot use endorsements to relate the specific result or outcome in a case. You can't have something on your website saying, this lawyer was wonderful because he got me a $1.2 million verdict. And I'm going to come talk about why, but you can't do that with an endorsement, just like you can't do it with anything else, even if they, in fact, did get him that judgment. And also, you can't compare your services with others in a way that would violate the rules. This lawyer was great. The last 2 lawyers I had before him were louses and didn't do anything right. You can't do that. There are certain things that are prohibited. You can't market yourself as a national practice if you only have an office here in North Carolina. You may do work in other states, but that's going to get you into trouble potentially with other states if you're claiming you do work outside and you only have one office here or multiple offices in North Carolina. The biggest thing is generally you cannot have statements about your record or your firm's record in attaining favorable verdicts. It's prohibited in virtually every other type of advertisement. I'm going to talk about a possible exception here, but the idea behind it is it creates unjustified expectations standing alone. If you have something on your website where you say, we got a verdict of X amount, people read that, the State Bar thinks, and think that they're going to get the same amount. Now, theoretically, and the opinion actually that I read from initially where they're talking about the web page back in 2000 was one where they had actually submitted one. In that opinion, the State Bar does acknowledge that it's possible to provide enough context in a website to avoid having that being misleading. But the conditions they've put on that in that opinion are pretty severe. Essentially, in order for it not to be misleading on a website, you'd have to put your unfavorable verdicts and settlements, your success in collecting your favorable verdicts, whether the cases were contested, whether the opposing party was represented, etc. It's all set out in that opinion. Obviously, the marketing value of putting a favorable verdict on there decreases substantially if you have to talk about all the cases you lost. But I think the State Bar really does have a legitimate purpose here, and the purpose is, to keep somebody who, for example, went out and took a case where there was a default judgment entered for this exorbitant amount, was never contested, and then they go put on their website they obtained a $5 million verdict. That's really misleading, I think, and the State Bar that's primarily what they're after, is to keep people from doing that kind of stuff and misleading folks. But in essence, to date, to my knowledge, the State Bar has never approved any verdicts, records, or settlements on a website. So theoretically, it's possible, but in practicality, either you can't do it, or if you did it, it probably wouldn't be worth it because it wouldn't be very effective marketing by the time you put everything in. The next category of stuff is what the State Bar has allowed or not allowed as far as attracting clients. There are lots of things out there. I'm going to focus on a couple of ones that the State Bar has specifically approved. This is kind of almost, I included it in here, but it's almost old news at this point. They have approved lawyers' participation in an online national legal directory as long as it's not false or misleading. That would include everything from Martindale-Hubbell online directory to all the other ones out there. The only thing really worth mentioning of that is that you just need to know that you are responsible for what's on their directory. So with Martindale-Hubbell and other respected organizations, you probably don't have to worry about it too much. But if you're going through somebody that you're not as familiar with, you need to double check to make sure the information on there is correct, because you're responsible for what's on their directory with respect to your information. Probably the more interesting one, at least to me, is the State Bar approved participation in what they called an online legal matching service, which to me I think this is a good idea for people, especially that are just starting out. It essentially creates an electronic marketplace for clients to be able to find a lawyer for certain types of service. Essentially what happens, the lawyers agree to participate in the service, and they pay a certain amount up front to be able to participate. Clients then find the service, and they post a problem essentially on a message board. And the lawyers then can check the message board periodically and write in responses to that person about their problem. They can talk about anything they want to. If you want to talk about legal advice, you can do that. I wouldn't recommend it, but you can talk about fees. You can give them basically your experience level. But ultimately, what saves this, because it was a for-profit service, it's not really a referral service, because it's the client who ultimately gets to make the decision about which lawyer, if any, they want to hire, as opposed to a referral service, which essentially you pay your money and the referral service says, here, you go to this person, or you go to these people. And so the State Bar said that's fine. The other point I'd make about this, I've seen over the years a ton of variations on these things. Some of them are reputable. A lot of them really aren't. So if you're considering doing anything like this, I would highly recommend that you get some more information about it. Call the State Bar, call somebody who does that kind of work to make sure that whatever you're getting involved with is not a violation, because there are lots of variations, more than I can cover. Some of them really are very shady. So just be careful if you're going to do this. I think this program in particular was a good way to do it. Okay. This is somewhat in the category of soliciting clients through the internet or through the website. Most firms, even small firms these days who have websites, as I'm sure you know, have email addresses on the websites. Most of them, I would say, also have direct links where you can basically click on the email address and go right to sending an email. Very convenient, but it really does raise some questions about what information is conveyed. And so most firms, certainly most big firms, I think most small firms, and any cookie cutter website you go to is going to have similar kind of information, are going to have disclaimers or terms of use or something along those lines. And the purpose of those really is to attempt to avoid disqualification when you receive an email on your website. Let's say, for example, you do domestic work. You've got a website out there. You're already representing the husband in a domestic case, and the wife finds your website. She doesn't know yet that you're representing the spouse, and sends you an email with all kinds of confidential information in it. Now you've gotten it. If it comes straight to you, you've received it, and if you read it, you may very well be conflicted out, and you're going to have to now tell your client, I'm sorry, I'm going to have to get out of this case because I've got confidential information about the other side. So unlike, for example, a phone screening where you can control the type of information, the emails really leave it to the person who's searching around for it. And that's part of the reasons for the disclaimers. There's a number of ways to do this, and I want to talk about some of the ways that are out there. I'm going to show you a couple of websites, not for any particular reason other than just I happened to find them, thought they were good examples of different ways. But there are essentially two ways you can do this. The most common way is what's called the browser wrap terms of use. That's essentially, it's a fancy word for saying essentially that you have a disclaimer or terms of use somewhere on your website. And somebody can look at that disclaimer, and if they choose to, they can click on it and go read the disclaimer. Or you may even have something that says, please read our disclaimers before using the website. And it has lots of things on it. The problem with those, even though they're most common, is outside the legal context, they've been pretty difficult to enforce because you have to basically show that the person agreed to it, and you're probably not going to be able to show that they even read it. The other, I guess, a little bit more sophisticated and difficult way to do it is to do what's called a click wrap terms of use, which essentially, if you've installed software in the last couple of years, you have an idea of what I'm talking about. Anytime you try to install software on your computer, you will have a box, and it says, here are the terms of usage for this software, and it will make you click I accept before you can actually install the software. That's essentially a click wrap terms of use. Law firms out there, it is difficult to do, who have actually required people before they go on the websites to click it. And then there's no question that they can't get any further on the website until they do that. Obviously, just from a legal standpoint, much easier to enforce. The language of disclaimers, there's a couple of things. I'm going to talk about these, and I want to kind of flip to a couple of sites that I found to sort of show you what's out there. One is what I call the no confidentiality approach, which essentially says the law firm's not going to keep any information I sent confidential if I transmit it, which is fine. The problem with that is if you end up representing that person, let's say, for example, probably the best example of this is you have that kind of disclaimer on there, but let's say you're a bankruptcy attorney or some other person where you want to collect some basic information up front, and you have something on your website which collects information before there's ever even an agreement to represent. The problem with that approach is if you use that and you end up representing the person, then more than likely the information you got on the front end before you actually had a representation agreement, none of that's confidential anymore because you've said it isn't confidential on your website. So if you're going to use that kind of, if you're going to take information in, you want to be real careful about saying, I mean, a particularly savvy lawyer on the other side went to your website, realizes you get all this information from your clients up front and says, let me have it all because you say it's not confidential right on your website. So that's a real risk of using that in and of itself. Another approach, and a lot of times these are combined, is the no attorney-client relationship approach. Basically, you understand we're not creating any kind of relationship just by transmitting this information. The problem with that is it's really not clear what happens with respect to that confidential information. If you get it, what happens with it? Are you going to use it? Are you not going to use it? Are you going to be disqualified if you get it? It's just not really complete. I'm going to stop there for a second, and I'm not picking on any firms because there are lots of decisions involved in this. One of them, a very important decision, is a business decision about how bad and aggressive do you want to make the terms of use, because the more aggressive they are, the less likely people are going to actually respond. So there are lots of things that factor into this. But I did pull some websites up that I thought were pretty indicative of what is out there. And I just want to show you a little bit. I tend to pick mostly on the bigger firms because they have mostly the good disclaimer language on them, at least the most common one. Now here's one for Pointer, and this is kind of their disclaimer page. You can see on the left-hand side there, that's the disclaimer. It's a browser wrap, basically passive. You have to go actually look at it before you can find it, and it has a number of disclaimers down here. One of them is the email disclaimer, which is essentially a combination of saying there's no attorney-client relationship here, so the information you send is going to be confidential. It's fine, but there are some issues involved in that and things that play into it. Let's see if I can find another one here. I'm going to go, just for the sake of time, I'm going to go to Ellison Winters has one. I thought the interesting thing about Ellison Winters' site was that they have a lot of this information in here. They have probably the most comprehensive one I've found. I'm sorry, I have to kneel down because I can't read this on the screen. But essentially, they have one that says attorney-client, no attorney-client relationship, don't send us information, and this information isn't going to be kept confidential. But the thing that I thought was interesting about this, and one of the things I'm going to recommend in the disclaimer language, is it tells them, basically it tells potential clients, here is the information we want you to send. Don't send anything else. And it tries to limit what comes out. I think that makes it a lot more reasonable for if you get beyond that, you can go back and say, look, we told them not to send us more information, and we shouldn't be disqualified if they chose to do that. One that I know that was just recently revamped, and that's why I'm picking it, I think it's probably, other than a click-wrap disclaimer, this probably would be the most protection I can imagine, and I don't have internet access here, so I can't walk you all the way through it. But this is the Everett Gaskin's site that they just redone. And in their contact form, where you actually would send them an email, They have it down here, and they say all the things that you would expect them to say. The difference here, and this is a common, I think most firms have, most of the sites that I looked at have it. So you have this disclaimer down here in the contact information about how to contact us, but then you also have separate attorneys pages. Almost all of them do, and almost all of them have emails, and you can almost always go straight from that email to an email, to an email address to an email without ever having gone through the disclaimer. So the problem with that is you don't ever know. The thing that I thought was interesting about that maybe you might want to consider with the Everett Gaskin site, no matter where you try to email somebody from that site, if it's on the individual pages or not, it brings you back to this page. So you cannot send an email without having seen at the top of this page the disclaimer. And so, that's one way without actually making people click. There's no way that you can send an email from that address without actually seeing that disclaimer, which I think is helpful. Judge, where are we on time? I was distracted. Do you know? Is it Shannon? Okay. I think we're about 15 minutes out. Okay. I just want to mention this. This is actually in the manuscript, but this is probably the most comprehensive issue, and the disclaimer that incorporates all these things. First thing, it is a click rec. It doesn't necessarily have to be that way, but that's the way I've structured it. It talks about not having an attorney-client relationship. One of the things that I think is important is that you tell people up front, don't transmit confidential information. If you're contacting us, and this is part of what you saw in Ellis Winters, please limit what you send us to the following: your name, names of the other persons involved, and a brief description of the types of cases. That's basically so you can do a conflict check before you get any more information. And then go on to say, this is the one that I really didn't see. There are probably websites out there that have something similar, but I didn't see any. You further agree that our review of any information you transmit will not preclude our firm from representing a party directly adverse to you and from using this information, even if it's confidential. Now, obviously, that's very aggressive. And you may not want to, for business reasons, put that on there. But what it does do is it says, this is all we want. Don't send us any more. And if you do send us more, we're going to use it. So beware. And I think from my standpoint, from protecting yourself from disqualification, that last provision is pretty important. And it's not very common from what I could tell. Okay, I want to talk a few minutes about the virtual law office. As I said, there's a recent opinion out there which talks about this. They've approved this arrangement with some qualifications in this opinion 2005 FEO 10. It's in the materials if you want to review it later on. The idea behind this is the virtual lawyer neither meets with clients nor maintains any office to do so. So the person, like I said, it's virtual. They have no office. The only way they either get clients or provide services to clients is through the internet and the website and email and possibly a phone. There are a good number of restrictions. The State Bar said this is okay, but here are some things. And this is, I mention these not because I think anybody here is probably likely to go into the virtual law office business, but if you're providing legal services, some of these issues are going to be the same. If you're doing it on the website or the internet, you're going to have the same sorts of issues. The first issue is you've got to avoid UPL. If you're going to provide services over the internet, you need to make it clear to people where you're licensed and where you can actually provide the services. Also, you've got to make sure you're not violating advertising rules in other jurisdictions. Similar point. Probably the most important thing is you've got to be able to provide competent representation given the limited client contact. You've got to assure yourself that you have enough information to be able to competently represent somebody. Also, creating a lawyer-client relationship unintentionally, same kind of issues that were involved in the disclaimer. And most importantly, ensuring that client confidences are protected. Of course, that's true with respect to any electronic communication, but particularly if that's your exclusive means, you can't have sensitive in-person conversations with people about something. You're going to do it all through the internet. And I think, if this seems like sort of an esoteric subject, One of the things that is probably, I think, probably more important in that opinion is the idea of unbundling legal services. That's really what this is designed for, and basically what that means is you can separate out different functions and only provide those things on an as-needed basis. Some things that are provided typically are legal. You just draft legal documents for people. You don't have full representation. Or you review the documents that they draft. This is actually something I do pretty regularly for clients because I represent folks before the state bar and other professional licensing boards. They typically do the initial informal response. All I'm doing is looking at what they see, and I think increasingly that's become common. Let the clients do as much of that as possible because they can't afford the full representation. Even things like case evaluation or coaching people as they go through litigation. You can do it as long as you can assure yourself that you can do it competently. And that really has become, the ABA has really pushed that issue strongly to try to get more people who need legal services to have them and be able to afford them. And in case you think, I don't know how well you can read that, but in case you think this is just some esoteric subject, that's the front page of a Lawyer's Weekly from less than a month ago announcing that a lawyer in Wilmington is now the first to have a completely online virtual office. It's not common, but it is happening. I wanted to take just a minute and take a look at that site, actually, because I think it's interesting to look at. It's interesting in part because it shows the type of things, even if you're not going to have a virtual practice entirely. This is this person's site, okay, and she is providing all the things. Basically, these are the things that they can offer. Legal questions, and she has a separate page which basically says, I do legal document drafting, I do consulting, and basically you sign up and you pay as you go. I don't know if she takes a credit card. I didn't actually sign up myself, but I think she probably takes a credit card, and as she works, she bills your credit card for it. So it's different. The other point I wanted to make is even though that is not practice, there are people right here in Triangle who are doing similar kinds of things. This is the law firm here out in Cary who, although they're not virtual, they actually have offices. They are using the internet to have people do all the initial work. They get all the information up front from people, prepare the documents, and then they just sit down and actually do the execution of the documents with the clients in person. So I think you will see, if you're not already seeing, increasingly that becoming more common, using this. And of course, they pitch it as a way to save costs to people who are trying to get a will. So I've got just a couple of minutes left, I think, and then I'm going to quit. The last thing I wanted to talk about was what are called application service providers. I imagine some of you are already familiar with these kinds of things. It includes a whole range of things. And the idea behind it is to get, to efficiently use services in practice and personnel for, particularly, it's used for large law firms, but I think it's particularly useful even for smaller firms where you don't necessarily need all these things in-house. Examples, electronic file storage, electronic backup service. That's one that I actually started using in my new practice, which is great because essentially what happens, I pay a minimal amount per month, I'm connected, and every night it offloads all that information onto the internet somewhere else, and I don't have to keep track of tapes, I don't have to have somebody backing up every night, I don't have to worry about having a separate storage, and it is extremely minimal cost, very safe, it's at least as safe as having you wired, and it really reduces the amount of time and personnel you need. Same thing with client billing. The main thing you really, they're all different. Online document production, if you don't have staff who can do large production documents, you can now put all that together and send it off to somebody who will then produce all those copies for you without you having to have personnel. It really has opened up a lot of possibilities, particularly for solo practitioners that can get the same kind of information. The main thing you need to worry about with those is security and client confidentiality. If you're not technically inclined, sometimes that can be a challenge. I would suggest to you, not exclusively, but one way to do that is to see if there are other folks who are using this kind of technology. When I went to use that e-file backup, one of the things I looked into, first thing IT guy was, who else is using this technology? And having discovered that there are other big firms out there and other lawyers who are using it and talking to them about it, I was comfortable that that was just as safe as having firewall in my office to keep all that information protected. But it is the lawyer's responsibility to do that, and it's important that you make sure that you don't get yourself in a situation where you're disclosing a lot of or subjecting all that information. So I think I'm right at the end of my time. I don't know, Shannon, if I have any more, but I'll be glad to either take questions now if we have any time, and if not, be glad to stick around afterwards and answer any questions you might have. Okay. Anybody got any questions, hopefully, that I can answer? He wants to know, I think you're asking about the electronic file backup storage. It is essentially, as I understand it, unlimited as far as time and space. You pay basically by the amount of storage. So if you have a lot of files, the costs increase. And over time, obviously, your storage is going to get bigger. But as far as I know, there's no limit on the time or the amount that you can back up. And the cost difference is pretty marginal. I mean, just to give you an idea, we're talking about, for a solo office, $10, $15 a month to do that. In the back? Come talk to me and I'll get you that information, only because I was told initially, but having just recently started an office, the vendors are kind of flying around in my head, and I can't tell you right off the top of my head, but I certainly could get you that information. Yes? You saying? Huh?
Repeat the question.
The question was, if you have links on your site that go to other things, what obligation does the lawyer have with respect to those? I think that's a little bit hard question to answer. I think generally speaking, you're not going to be responsible for the type of information that's on there on another site that's just linked. Most of the disclaimers that I showed you, you couldn't probably read them, but they said we're not responsible for the content of other websites that may be linked from here. On the other hand, I would say that the State Bar is likely to think that if you link to something that you know is clearly not true or misleading, you're probably not going to get insulation from that. That's an interesting question about linking to a page that has a verdict on it. The question was, would that be a problem? I don't know that I can answer that question. I'm sure the State Bar has not answered that question. My guess would be if you reference it on the site, you certainly wouldn't be able to do it. I don't know whether you could do that or not. The one thing I do know is before I did it, I would submit it to the State Bar and ask them, because you don't want to get crossways with them about it. But that's a very interesting question. I don't know the answer. Yes? I understand. I thought about that actually today as I was getting ready. How are they meshing that? The opinion really doesn't address it. The question was, how do you reconcile the fact that the State Bar initially says you have to have a physical office address, and yet they've approved a virtual law firm who, by definition, doesn't have a physical office address. I don't have internet access, so I can't look at that site. I think probably the way that's been resolved is the person lists an address, probably a home address, because from my understanding of the article, that's where she's practicing out of, but does not meet with clients there. The purpose of that rule really is to make it clear where you are, because there were a lot of lawyers, particularly in Virginia, who came and got licensed here, and they would come down and they would meet with clients down on the beach in the Outer Banks in hotel rooms and sign up all these clients and then go back to Virginia. And there were a lot of lawyers in Eastern North Carolina who were very upset about that, because when the client wanted to get a hold of the lawyer, they didn't know where they were. So I think that's how they're getting around that. There is a physical office address to show where they are, but she's not actually meeting with anybody at that address. Any other questions?
Thank you. And for those of you who have not met Katherine, she has been in private practice for 19 years, but now she is co-counsel with the Office of Counsel for the North Carolina State Bar. So maybe you ask her all the ambiguous questions that we were wondering about before. Thank you to Katherine.
Thank you. Good afternoon. I do work in the Office of Counsel, and a lot of things go on in the Office of Counsel. When I was practicing law for 19 years, I had no idea about what went on over there. My idea was to kind of keep my head down and not interact with the bar any more than I had to. So it was very eye-opening to go to work at the State Bar and find out about all the things that do go on. A lot of what the Office of Counsel does is the grievance and disciplinary program. And so people sometimes will refer to us as prosecutors, and I don't like to think of it that way at all. I like to think of it as trying to help the lawyers not to run afoul of the rules of professional conduct, and we kind of joke about how we're going to eradicate attorney misconduct in a year and all these things, and but that really is our goal. In 2005, we had 1,418 grievances opened against lawyers. The great majority of those come from clients who are unhappy about the outcome of their case or about some conduct of the attorney. It would have made the State Bar very happy if we could have dismissed every single one of those as having no merit. Unfortunately, we're not able to do that. But of the 1,418 grievances filed, we were able to dismiss 1,179 without any disciplinary action at all. So a lot of the disciplinary action that was taken is fairly low-level stuff like letters of caution and letters of warning, and the incidences of serious attorney misconduct are very infrequent, so we're happy to report that. And we all realize, of course, that all of y'all here and most of the lawyers in North Carolina are just trying to do a very good job, and it's just a few, who keep me in business, I guess. So I wanted to talk about two things, which is what to do if you should receive a grievance, and secondly, how to avoid receiving a grievance. I may be backwards, but I'm going to start off with what to do when you receive a grievance. Surprisingly to me, we have a lot of attorneys who are notified that there's a grievance, and the grievance has no merit at all. But they don't respond to the State Bar. And so they end up being disciplined for not responding to the State Bar, even though there was nothing to the underlying grievance. And I think that this happens sometimes because they think, well, there's no merit to that, I don't need to respond to that. When the State Bar sends a letter of notice and asks an attorney to respond to a grievance, it doesn't mean that the State Bar has any opinion that this has merit. It means, it's just like if you were in court and someone files a lawsuit and they've successfully pled it so that it survives 12b-6. That doesn't necessarily mean that they're going to prevail. It just means that it needs to continue a little further. So if the State Bar sends a letter of notice, it just means this person has successfully claimed that you did something wrong. Now we'd like to hear your side of the story. I equate that to if you were representing a client who had been sued, and you read the complaint and said, oh, there's nothing to that, they're not going to win that, and you just don't bother to file an answer. You wouldn't do that. You would go ahead and file an answer, and you would proceed on with the appropriate steps, and that's what we need for lawyers to do here as well. We do have an awful lot of grievances that we receive that don't have any merit. We're going to open a grievance file if someone complains about lawyer misconduct and the complaint is not essentially a fee dispute. The fact that we've opened a grievance doesn't mean that anybody has vetted it and decided that there's anything to it. We just open them. My favorite example of one that has no merit is I received one of these early on that said, this lawyer who represents the other side sued me 3 days before the statute of limitations was going to run. And if he had waited 4 more days, I wouldn't have had to pay this money. Well, when I was new at the State Bar, I looked at that and I thought, I don't understand. I don't. So we dismissed the grievance. We sent a letter to the complainant saying we found that there was insufficient evidence of a rule violation, and the person responded to that by sending me all of her medical records showing that she conclusively demonstrating that she in fact owed this debt. So that was sort of eye-opening for me, and now I get that all the time and it doesn't really throw me anymore, but that was one of my first grievances and I really was kind of confused by that. So don't panic if you get a grievance, but do respond in a timely manner. This is just something I've asked you as a personal favor to me. If you happen to get a grievance, please send in your response on a timely basis, but please don't call me to confirm that you did that. I get calls all day, every day from people saying, well, voicemails, please return my call and let me know that you received my response. I kind of equate that to, when you send your tax return into the IRS, you don't then call and ask them to call and confirm that they got it. You trust that they got it. And, if you have sent in a response to the State Bar and by some chance it got misdirected and we didn't receive it, that can all be cleared up later, but please don't just call to confirm that you've sent something. If there's nothing to agree to receive, just calmly and rationally describe to us why that is. It's really a bad idea to attack the client or the complainant and to talk about what a nut the complainant is or how irrational they are, how unreasonable. They've written to us to start this process, and if they're a nut or irrational, we'll figure that out. I mean, it does, we've read their correspondence. So, it is to an attorney's credit to rise above the understandable impulse to attack a tiresome, irritating client, but you get credit for that. You get brownie points, and it's not, the State Bar doesn't impose discipline based on whether we like you or whether we think your attitude is good, but a lot of times these grievances are a he said, she said. The client claims that you didn't tell me about X and such consequences of my plea agreement. And the lawyer says, well, yes, I did. Now you've got a credibility dispute. Well, if the lawyer has responded to the grievance in a professional, appropriate manner, that tends to lend credibility to the lawyer. And it's not, in some of these cases, the grievance committee is called upon to make judgment calls about the credibility of the two sides of the issue. So by behaving in a mature, professional manner, you'll increase your chances that the grievance committee will decide you're the credible of the two. This probably should be able to go without saying, but it's also a good idea not to attack the State Bar or the grievance chair. It surprises me that this is not obvious, but I recently had a case where an attorney responded to the grievance by writing his letter to the chair, at that time Henry Babb, saying, "Dear Mr. Babb, this grievance is expletive." And went on and on about every time I get a client, I end up with a grievance with you people, and you just harass me, and you're so tiresome, and you're obviously persecuting me. And what the man doesn't understand is we have no idea who his clients are. We would have no means of going and soliciting grievances from them. They are contacting us, so they're unhappy. But his approach to the whole thing is to attack Mr. Babb and all the other people who work at the State Bar. It should come as no surprise that this did not curry favor with the grievance committee. Again, the grievance committee is not going to discipline this lawyer because he's rude to us. But again, his case boiled down in large part to a credibility dispute between him and several clients who claimed the same conduct. And so naturally there was some credibility to their complaint simply by the volume of it. But he didn't help his cause at all by behaving in this manner and being very belligerent toward the State Bar. He ended up with a reprimand. It is so helpful to an attorney who has a grievance to really objectively look at the grievance and see if maybe they did make a mistake. And lawyers do make mistakes as much as we like to think otherwise. And some of these rules, I know Doug was talking about some things here that many of us may never have thought about. And someone could easily accidentally violate one of the State Bar rules in dealing with a website without having any intention to do that. It is a very good idea if you receive a grievance and you go and analyze a rule and determine that, I think maybe I did do something wrong. Fess up. It's so much better to say, I didn't mean to and it was totally inadvertent and I get it, I understand now, I'll never do it again. That is so much better than splitting hairs and trying to explain why that rule doesn't actually apply to me. Because if the rule is determined to actually apply, now all of a sudden, you are somebody who hasn't recognized the problem. Again, the State Bar is not in this to punish lawyers. We're here to protect the public. If a lawyer has said, I get it, I understand, I'm sorry, I won't do it again, that person doesn't need discipline. But if the lawyer persists in saying, this conduct is okay, and I get to continue to do this, and y'all have got it wrong, well, that lawyer does need discipline because that lawyer obviously has not yet learned the lesson. So if you accidentally make a mistake, just say, I made a mistake. It makes a huge difference. There's a case actually involving the exact same subject matter I can point to where there were 3 lawyers who were doing exactly the same thing. And it all happened at the same time, and two of them, did the mea culpa thing, and theirs were dismissed, and the one who just persisted in saying, it's okay for me to do this, you're the ones who were wrong, ended up getting disciplined. So, another thing, when you respond to a grievance, provide any relevant documentation, but again, as a personal favor to me, please don't send your entire client file. If you will just pull out the pieces of paper that are relevant, for example, if there's an order allowing you to withdraw, and that's the sort of the answer to the question, please don't send me everything else in your file. And not just as a personal favor, but it muddies the waters and makes it unclear to the State Bar what is the issue. If you send all that stuff, we think, well, there must be a reason you sent all this, so I'm getting off track. Where if you sent me the order allowing you to withdraw, that would just, obviously resolve it all in my mind. I wouldn't need to look any further. So, even the best lawyers get grievances filed against them. You can't control what your clients are going to say. And so, don't panic, but there are some things you can do to minimize your chances. The first thing you can do to minimize your chance of getting a grievance filed against you is to not take on the cases of people who you can tell are going to be tiresome. You have people come into your office and they're unreasonable and they're unrealistic and they're demanding and you don't like them. Don't take this case. Some people, I'm finding out I don't get to pick my cases anymore either, but if they're that bad the first time you meet them, it's not going to get any better. And those are the people who complain. And it doesn't matter what kind of wonderful fee you might get out of this case. I will promise you, once they file that State Bar grievance against you, you will wish you had never seen them. So that's the first rule. Just stay away from these people. The biggest areas in which we get grievances are criminal law and family law, and you can obviously imagine why that is. The biggest complaint that people have is that they claim that the lawyer did not explain to them the terms or implications of a separation agreement or a plea agreement. Very often you will find that there is no documentation that the lawyer has in fact explained it. You just have, he says I did, he says I didn't. It's a really good idea in those cases to write a letter to your client explaining what the proposal is, explaining the implications, explaining your advice, and saying it's your decision. This is going to save you an awful lot of pain. It is time-consuming, but it's not as time-consuming as having to deal with us. So that's one thing you can do. All of this really boils down to communicate and then provide documentation showing that you did communicate. We get a lot of grievances about lawyers not communicating with their clients. Again, it's really, a lot of times it's the tiresome clients you don't communicate with, because you come home, you come back to the office after a long day, you're really, kind of frazzled and you're kind of tired, and you don't want to have that conversation that you've had several times already with this client who's very repetitious and tiring. But not returning the phone call is not the answer. Now, we talked about email earlier, and certainly there are problems with email, but email can be a godsend because you can respond or communicate with your client, if your client uses email, when you have the time and when you can compose your thoughts and when you don't have to endure a long, repetitious conversation. Obviously, you don't want to communicate a highly sensitive information in an email without taking a lot of precautions. But a lot of the complaints we get are, my lawyer didn't tell me I had a court date. My lawyer didn't tell me that the other side had sent discovery requests. My lawyer didn't communicate a settlement offer. Well, all those three things, none of that's confidential or, private at all. You can easily communicate that in an email, and if you can get the client to send back a confirmation, all the better. Now you're creating a paper trail. You don't want to have an email paper trail that is 35 emails from the client and no response from the lawyer. That's really bad. So if you're not going to use email responsibly, I recommend you don't use it at all and don't give out your email address. How am I doing on? Am I okay? Okay. Let's talk just for a minute about fees. It is a really good idea always to have a written fee agreement, even better if the client signs it. Unfortunately, the rules don't require that you have a written fee agreement except in contingent fee cases. And they don't require, except in contingent fee cases, that the client sign the agreement. So it is just good common sense to have a fee agreement that spells it out and get the client to sign it. Please don't put any language in your fee agreement that says you have a charging lien. The case law is very clear, and the State Bar is pretty firm on this point, that lawyers do not have charging liens if they withdraw or are terminated in a case unless at the time the representation ends, the lawyer has actually obtained a judgment or has received funds in settlement in the lawyer's possession. There's a case called Mack versus Moore from 1992, North Carolina Court of Appeals case, and it's very clear that you cannot do this. So the state bar will consider it a violation of the rules to have a fee agreement that says I have a charging lien, and they like it even less if you try to enforce that by writing a letter to an insurance company and saying, I used to represent client A, that relationship is over, but I have a lien against these settlement proceeds. Don't send a check to that client without paying me first. So the state bar does not like that. The grievance committee really doesn't like that, and they react very strongly to that. And that scenario kind of goes hand in hand. Another scenario, which is unseemly squabbling over clients, which when firms break up or people leave firms, a lot of times we have these unseemly squabbles over clients. And one of the things that people will do is say, oh, well, that was my client, and I'm going to send this letter about the charging lien. So I'm going to get my money. So you combine two things into one case, and the grievance committee really frowns on this. And they have given an attorney who had no prior discipline, who had been practicing law for 25 years, a censure for this unseemly squabbling over clients and attempting to assert a lien that didn't exist by law. So take that very seriously. I recommend that you read Mack versus Moore. Let's see. If you are billing hourly, send a bill monthly or some other frequent period. We get a lot of complaints because there's a monthly billing or an hourly billing arrangement, but no bill comes, and 9 or 12 months into the relationship, a great hunking bill comes, and clients become very upset. And I try to look at this as like, how would I like it if my cable company never sent a bill, and then all of a sudden they sent me a bill, 16 months into the relationship? I wouldn't like it either. It is an easy way to avoid a grievance because the client obviously, is being kept abreast. Another thing about that is if the client is later inclined to come along and say, hey, that was a clearly excessive fee, if you've been sending monthly bills and the client's been paying them all along without objection, that's gonna help as a defense to the idea that somehow the fee was excessive in hindsight. The last thing I'd like to say is the state bar has an ethics opinion that says you cannot call a retainer a non-refundable retainer. You can't call it in a letter, you can't say it out loud, you can't put it in your fee agreement. The theory behind that being that any retainer, any fee is always theoretically refundable under certain circumstances if it turns out in hindsight to be clearly excessive. So please don't use the phrase non-refundable retainer. It is misleading because it implies something that the state bar said is not the case. So be happy to take any questions. Do I have time?
You do have time. I did not know if you would definitely split.
Yeah. Do you want to play Alan now? Okay, thank you.
I'm not actually Alan Schneider, but I'm going to play him for the purpose of this seminar. The idea behind this program initially was to have somebody from the state bar who could kind of give the state bar's perspective. Alan Schneider was going to do, as some of you know, does a lot of work. He wasn't able to make it, and I also primarily now represent folks before the state bar and other licensing agencies, respondents. Prior to that, I actually worked at the state bar investigating and pursuing disciplinary cases. So somewhat of a unique perspective on that. And I wanted to just follow up on a couple of the things, or the general topics. I'm not going to repeat what Katherine says, but there were a couple of things about avoiding grievances and responding to grievances, primarily from the respondent side of things that I would just highlight to you. As far as being selective with your clients, that is obviously very important. The other thing I would just follow up on Katherine's point is, if it's a client where you're sort of on the fence about whether to take the case, the other thing I would highly recommend is that you consider the type of client when you're structuring the fee arrangement if you have anything other than an hourly arrangement. For example, if you're on the fence and you can't decide whether to take it and you have a client that you can tell from that initial meeting is going to be calling you every day, asking you the same questions over and over again, and wanting to email with you 5 times a day, take that case on an hourly basis, because I think what I've found from folks is a lot of the cases that end up in grievances are because of the nature of flat fee, and they take a certain amount, and then the client is just abusing that amount, calling all the time, and you end up feeling like you're not going to deal with it for a number of reasons, part of which is they've already more than eaten up all the fee a long time ago. So that's just another thing to keep in mind. I think you're more likely to continue to deal with it if the fee arrangement is structured appropriately. Another thing that can help avoid some grievances, and if you've gone to Lawyers Mutual, you've heard them say this before, is whenever practical, send either non-engagement letters for people that come see you and don't end up hiring you, or disengagement or termination letters when you're actually finished with something, to make it very clear, even if it's you think it's a logical termination. If you're sending out bills, the last bill you send out, just put that in writing so that there's no ambiguity about what's going on, particularly if it's a matter where there's other issues going on that you're not involved with. Another point about avoiding grievances that I probably saw it more when I was at the State Bar than I have now, but about training and making sure your employees understand your obligations, your non-legal employees, even your associates, maybe young associates, what the confidentiality obligations are. The biggest point about that is you cannot assume that anybody coming in there, even if they're a paralegal that's been trained, or even a lawyer, frankly, a lot of times a young lawyer, knows all those rules. My favorite story about that, about the importance of not assuming things, I handled a case for a lawyer out of Wilmington, and unfortunately when we got in and started auditing his trust account, realized that his assistant had just been essentially picking wherever there was money in an account, that was where the bills got paid out of. So if the rent came due and the operating account had some money in it, then they paid it out of the operating account. If not, she'd just go over to the trust account and take a little loan for a little while. And so we were asking him about that, and it was actually in a deposition, and I asked him, well, did you ever tell her that she wasn't supposed to take money out of the trust account? Well, no, I just assumed she already knew that. And, she had worked at another law firm before, so I assumed she knew how to do that. So I asked her the same question, and her response, when I said, well, why did you do that? She said, well, that's the way they did things down in South Carolina when I was in the law office. So you can't assume that people coming in your office, even if they have legal experience, know these basic principles, and you are responsible for things like that. Another point on the avoiding a grievance is advertising. If you're going to advertise, I always tell folks, if they come to me with it, be glad to talk to you, give you help structuring it, but I would not send out anything that would constitute an advertisement without going to the State Bar, calling the ethics hotline, and sending them a copy of what you're proposing to do. Because if you get that opinion, if you send them the advertisement and they sign off on it, you're covered. You cannot be prosecuted, or it cannot be found to be a violation. Even if the person whose opinion you got happened to be wrong about it, if they say it's okay, then you are absolutely protected. A good example of that, some of you may be aware of, the federal case was filed by a lawyer who did the Robert Vaughn advertisements. I won't mention his name specifically, you probably know who I'm talking about. But he had actually submitted an inquiry about that to the State Bar. It had been approved. And then subsequently somebody filed a grievance about it, and it was going through the grievance process, and he raised as a defense that he had gotten an opinion from the State Bar. And they stopped and said, okay, you got an opinion, we don't really necessarily agree with it, but we're going to refer it back to the Ethics Committee. The full Ethics Committee looked at it and said, no, we think this advertisement is misleading, but we're not going to discipline the lawyer because he got an opinion, an informal opinion from the State Bar about it. So I would highly recommend that you use that if you're going to use any kind of advertisement, and that includes, as I talked about before, websites. There's no reason not to submit that information. It's absolutely free. A couple other points about once you get a grievance and responding, if you were to get one. The importance of responding, I won't echo again. One of the things I like to talk about when I was at the State Bar, and I still like to say, is there's really a common misconception out there that the people making decisions at the State Bar are folks that have no basis in reality. They don't know what it's like to practice law, and there's just this esoteric discussions. Hopefully you can tell from hearing Katherine talk as a staff member, she's been out practicing for 20 years. A lot of the staff who works there have been practicing attorneys, but probably in all kinds of areas. But probably more importantly, no decision to impose discipline ever gets done unless it goes through the counselors who you elect and other judicial districts around the state elect. They're the ones that actually make decisions. They're practicing attorneys. So just keep that in mind when you're responding, because I think it's important to talk to and respond back in a way that recognizes that the people who are going to be making these decisions are practicing attorneys. A couple other points about responding. Extensions of time, never a problem to get one. I don't know that the State Bar has ever denied a first extension of time for anybody to respond. Just do it on time, even if you need an extension. Another thing that's happened to me recently that sort of reemphasized, if you're going to respond, don't do it from memory. Review the file first. People get themselves in trouble because they get something, they get very upset, and they just go ahead and shoot off a response very quickly without actually having reviewed the file. State Bar goes further investigation, maybe get some of the documents from the file. Turns out you were wrong when you responded initially. Maybe didn't do it intentionally, but you were wrong,